evening, everyone, and thank you for joining us. My name is Lindsay D'Souza, and I'm the Alumni Officer for Recent Alumni here in the Alumni Engagement Office. I'd like to take this time to introduce the Willful co-founder and CEO, Erin Bury, who will be leading tonight's presentation on estate planning. So thank you so much for joining us, Erin, and I'll throw it over to you.
Wonderful. Thank you so much, Lindsay. And thanks everyone for joining me on this Monday night. I'm joining you from beautiful Prince Edward County, Ontario, and very excited to talk about my favorite topic, which is estate planning. I want to thank McMaster for having me today. We've been a proud partner of McMaster for many years, and one of my best friends in the world is a McMaster prof. So Becca, if you're watching, this one's for you. And today we're really here because November is Make a Will Month, and it's something that so many of us haven't prioritized. I have so many great questions that were sent in ahead by all of you folks who registered tonight. So what we're going to do is spend an hour together talking about the basics of estate planning, getting into all of the ways you can leave a positive legacy, like leaving a gift to charity in your will, and of course, getting to so many of your questions. So I'll start by just letting you know that we have a worksheet that pairs with this webinar. You can go to willful.co/webinar to download that estate planning worksheet, where you can record some of the choices in your will that we're going to talk about today. You can, of course, do that on a pen and paper or on your smartphone notes app. It doesn't have to be on this worksheet, but we've tried to make it simple if you do choose to download it. I also wanted to highlight that estate planning is something that folks typically have a lot of questions about. So I know you already submitted some, but if you have questions as we go through, you can pop them into the Q&A or pop them in the chat. Lindsay's going to be also recording this session and sending it out after. So if you have to drop off, I get it. I have a 1-year-old. It is bedtime routine time. So if you can't stay for the full hour, watch for a recording in your inbox, and also watch for an offer at the end of this session if you do choose to make your will with Willful. So I'll start by just telling you a bit about the Willful story. So like a lot of great businesses, Willful was inspired by a personal experience. My husband, Kevin, who's pictured here with me, his uncle passed away in 2015, and he had a will, but he had never discussed the items outside of that, like funeral and burial wishes or where his important paperwork was stored. And so at a time when his family really should have been focused on grieving, they instead had all of these unanswered questions, and they were scrambling to find key documents and figure out what their uncle would have wanted. And it really struck Kevin that, even though he had been married for 40 years, his uncle had never talked about these end-of-life wishes with his wife. And so what we really looked to do is get our own estate plans in order. And we found that the only options were to pay a bunch of money to go in person and make an appointment in a lawyer's office. I very much want to stress, if you have a lawyer in your family, if you are a lawyer, we very much see ourselves as a complement to lawyers. As I'll talk about today, I care that you get your will done however you choose to do it. But for us, we were in our early 30s at the time, and we wanted to use something digital that was affordable, that we could do from home. And when we couldn't find it, we set out to build it ourselves. So I do want to highlight, I'm not an estate lawyer. I have estate planning designations, but we partner with estate law firms in each province. So the information I'm going to be talking about tonight is exactly that. It's information, not legal advice. And if you do want legal advice specific to your situation, you can find a lawyer near you on the Law Society website. So then the question becomes, well, why now? Why are we attending this session on a Monday in November? Well, the first reason is it's Make a Will Month in Ontario. So it's a month all about raising awareness and advocating for creating this important document. But it's also because of what we've gone through the last couple of years. COVID really showed that emergency plans need to be in place before you need them, and that the unexpected can happen anytime. The singer Aaron Carter passed away last weekend, and it came out this weekend that he did not have a will, even though he had a fiance and a young child. He was 34. And I always hear people say, well, I don't need a will, I'm young. And that's the point of a will. It's there just in case you need it. And we've seen, because of COVID, that a lot of young folks and people of all ages have been prioritizing this task, hence why you're attending tonight. So let's start with when you should create a will. So you need a will if you own a home. Once you buy a large asset like a home or a boat or even a car, it's an asset that you want to protect and you want to make sure it goes to the right person. You need a will if you have meaningful belongings you want to pass on, whether that's baseball cards or jewelry, art, or even heirlooms. Something passed on in a will doesn't have to have huge monetary value. It could be something that just has sentimental value. You need a will if you have assets of any size. I often hear people say, well, I don't need a will. I don't have celebrity sized assets. And honestly, even if you only have $1,000 in a savings account, wouldn't you rather it goes to the person you choose versus leaving it up to a government formula, which I'll speak about a little bit later? You need a will if you have a spouse. In Ontario, if you are in a common law relationship and you pass away without a will, your common law spouse is entitled to nothing under that provincial formula. So it's even more important if you're living common law to have a will that outlines that you'd like your assets to go to your partner. And when you get married, typically you do want to add that partner in to your will as an executor or beneficiary, roles we're going to talk about in detail today. You need a will if you have children. I went through this firsthand. I had a baby last November, just over a year ago, and I updated my will after she was born to add a guardian for her care in case something happens to my husband and I, and to add her as a beneficiary in case my husband passes away. And it was an emotional conversation and decision, but a really important one. And this tends to be the number one catalyst that causes people to create a will. But if you don't have children and you just have fur babies, pets are another great reason to get a will, to ensure that you've assigned a guardian for their care and left money if you're inclined to help out with their ongoing care. As we've seen with the rise of digital assets, it's not just, money in the bank that we have to think about anymore. So a will is a great way to ensure that whether it's crypto or NFTs or, that 2007 iTunes song library, it goes to the right person and that your family knows about it. And finally, you need a will if you care about reducing burden on your family. A will is not for you. It's like life insurance. You get life insurance because you want your family to be provided for after you're gone, and you never benefit from it. A will is the same. It's a document that is all about peace of mind for your family and making sure that the assets and the wealth that you work so hard to build in your life are flowing to the people that you would want them to go to, because everyone has something and someone they care about. And thank you for the question here. I will address these either as I go, or I'll leave time at the end to address them and keep them coming. So those are kind of the inflection points that cause you to create a will. On Willful, we did a poll and we found the number one reasons that people came to create their will was the loss of a loved one. Often when you lose someone, and like Kevin and I, you're wrapping up their life, it reminds you of, oh, I need to get my own affairs in order. Having a child, buying a home, and actually an interesting one, traveling without children. I'm going to New York without my daughter for the first time this weekend. So I'm happy to say I have all my paperwork and it's all organized in case anything happens. So let's start with the basics. What is a will? Well, a will is a very simple, high-level document that says who's going to wrap up your life when you're gone, who's going to get your assets, and who's going to take care of any dependents, whether that's minor children or pets. So, I often hear that a will is this arduous, really complex, time-consuming task. And at the end of the day, it's not. As you'll see today, it's about making 3 key decisions. And once you've made those, it's actually pretty simple to get it down on paper. And the great thing is that a will it stays in effect for as long as you live. So if you made a will tomorrow, it's not like you have to redo it every year to make it valid. And you don't also have to change all the details every time you get a new bank account, as I'll also talk about. So it's something that you can make and you can update it as your life changes, but otherwise your will grows with you. And when you pass away, it covers everything that you own at the time you pass. So why do you actually need one? Well, as I mentioned, a will is for your family. It's not for you. So this is really a selfless thing that you can do to give your family peace of mind and to give you peace of mind that you're not leaving a mess for them to clean up. It also just gives you a blueprint that they can follow. It avoids those unanswered questions like we had with Kevin's uncle. It removes that guesswork and arguing of your family, arguing over what you would have wanted and who should get what. And practically, it reduces the amount of time it takes to settle your estate. If you pass away without a will, the courts have to appoint an executor to wrap up your estate, which slows things down and means potentially higher legal fees for getting involved with that. If you die without a will, there's a government formula in each province that dictates how your assets will be distributed. And it often wouldn't match what you would want. It doesn't account for leaving things to friends, to charities, or to common law spouses. And for example, if I were to pass away without a will tomorrow, my husband would get half of our assets and the other half would be tied up in a trust for our 1-year-old daughter. So whenever people say to me, well, I don't need a will, everything would go to my spouse anyway. If you have kids, that's absolutely not the case. And I would definitely not want things tied up in a trust for 17 years without my husband being able to use it. And finally, a will means that you decide who is going to be the guardian if you and your partner pass away and there's no surviving parent. So it's a really key part of a will to appoint a guardian for minor children. And if you don't, the court's going to appoint that person. So if you have that brother-in-law that maybe you don't trust to watch your child, then definitely even more reason to have a will. And thank you for the question about Willful's pricing. I will get to that at the end. And I'll speak to including grandchildren in your will. Great idea. There's a question here about corporate wills, which I will get to in a moment. And I will also speak about trusts for children in a will. So all great questions, keep them coming. So I've talked about what a will is and why you need one. Again, it's not for you, it's for those you leave behind. But then the question becomes, don't I need to visit a lawyer? And it's a common misconception that you have to visit a professional to get your will done. And again, I want to highlight, if that's your comfort level, if that's what you choose to do, that's great. Right? A lawyer is a great option to get a will done. They're going to be the most expensive option, but you're also going to get custom legal advice for your situation. But I wanted to make it very clear that there's no legal requirement to have a professional involved with creating your will. So for a will to be legal in Canada, and this is the same in every province, it has to be written by you. You have to have the mental capacity to understand the decisions in the will. And it has to be signed on paper in front of 2 witnesses who also sign the will. Those witnesses can be any adult who is not a beneficiary of the will or their spouse. So for example, could be neighbors, family members who aren't beneficiaries. They can be a married couple. They can be anyone you want. And if you live in British Columbia, because I know McMaster alumni are probably spread out across the country, BC is the only province that allows this to happen digitally. So in every other province, you have to sign a will on paper. The witnesses also have to sign that physical piece of paper. In BC, you can actually sign that digitally. And we have a pilot program where we'll provide the witnesses and execute your will for free in partnership with DocuSign. So we're hopeful this comes to other provinces soon. Right now, it's only available in BC by law. So that's really it. As I mentioned, there's no legal requirement that there has to be a lawyer or notary involved. So when you use a platform like Willful, you can think of it like TurboTax. We guide you through the process of appointing key roles in your will. And we use legal templates that have been written by estate lawyers in your province. So what you're not getting is the advice from a lawyer that's specific to your situation, but you're getting affordability and convenience and lawyer drafted wills. It's essentially the idea of going to a lawyer, you're just getting it more templated. If one of your witnesses dies after signing the will, do I need to redo it? No, you don't. So the witnesses are meant to verify your identity. So, hi, I saw Erin sign her will. If one passes away and the other one is required to attest to that in court, let's say, then they would just do that. If both witnesses had died, then the executor would just have to provide another proof of your identity, like, for example, a signature on a contract. So you do not have to redo your will if your witness or both witnesses passes away. And the witnesses can be relatives of yours. Again, the only requirement is that they're not a beneficiary of your will or their spouse, and they do need to be adults. So the age of majority changes by province, but in Ontario, it's age 18. The witnesses do not need to know the contents of the will. So typically what you'll do is we have initial blocks on each page and then signature blocks on the last page. You can cover up the contents of the will, have them initial without seeing any of the content. They do not need to see the contents of your will. In fact, you don't have to share your will with anybody until you pass away. Richard has a great point about handwritten wills. So in every province except BC and PEI, handwritten wills are legal. So if you want the most affordable option, you can literally take a pen to paper and handwrite your will. This is the only type of will that does not require witnesses. The benefits are, if you're in a time crunch or you have estate planning knowledge, then you can do it yourself. The challenge is that most people don't know what they should be writing or the key things that they need to include. So most people want a more guided approach, but if that's how you choose to do it, it's absolutely legal. And I will speak to updating a will a little bit later. First, I wanted to speak to the types of situations that can add complexity and may not be a fit for Willful. I had a couple questions about Henson trusts in the document. It's a certain type of trust if you have a child or dependent with a disability. That's not something that we do handle on Willful, although you can work with a professional to build that into your will. I'm going to speak in a little bit about how Willful creates a trust for any minor beneficiaries, but we don't do any other trusts like spousal trusts, for example. Now, if you're a business owner, I had someone in the questions who is a doctor, you can absolutely use a platform like Willful. We have what's called a carry-on business clause, which allows your executor to deal with your business as if they were you. They can wind it up, they can sell it, they can continue it, and you can provide them instructions on what you would like to happen. But what we don't allow is creating a dual will, which is just a tax saving vehicle that separates your business assets from having to pay probate fees, which I'll speak about a bit later. You can also leave shares in a business as a gift in a will. For example, if I wanted to leave, my shares in Willful to my sister when I pass away, I'll show you how to do that a little bit later. We also don't offer, of course, tax and legal advice. So if you're not 100% sure if your situation is the right fit, I'm going to put our support details up at the end of the presentation. I'll just throw them in the chat right now. You can reach out to support@willful.co or willful.co/support. We have the ability to request a phone call. We have live chat during business hours. So not right now, but during business hours, and email support. So if you just say, listen, this is my situation, is Willful a fit for me? We're going to be the first to tell you, yes, we can handle that. No, we can't. And ultimately, again, the decision is up to you. So we've talked a little bit about how to make a will legally in Canada and what the document is. Now we're going to walk through the three key steps to creating a will. So this is when you can get that worksheet out, or you can just have your notes handy. The goal today is that you leave empowered to get your will done. And the biggest barrier to that is the three decisions I'm going to talk about now. So the first is choosing your executor. The executor is the person who's going to wrap up your life after you're gone. So it's answering that question. Who do you trust to wrap up your estate when you're gone? Most people choose executors like a bridesmaid at their wedding. It's a popularity contest. I have to choose my daughter because if I don't, she'll be mad. Or I have to choose both my daughters as co-executors because I don't want to pick one over the other. And the one thing I would stress is you can choose whomever you'd like as executor, but this is a really cumbersome job. And so it comes down to more than just who do you like. And so we'll talk about what's actually involved in being an executor. So this person executes your will and handles the estate administration, which is just a fancy way of saying they close up your life. So they're going to do everything from closing your Netflix subscription and all of your online accounts to dealing with your physical property like a home, selling that if they need to. They're going to contact all of the banks that you have accounts with and move those assets into a central estate account. They're going to handle your funeral and burial wishes. They're going to make a list of all of your debts and liabilities and pay those off and file your final tax return because yes, you do have to pay taxes after you pass away. I had a question in advance about estates and taxation. It's not something we're going to be able to dive into today, but we do have an article in Willful's Learn Center about that. I will post a link to that right now, and you can just search taxes and you will find an article about that. This person's also going to liaise with all of your beneficiaries, and they're going to deal with all the courts. They're going to, notify the government, and they're going to go through the probate process, which is the process of getting the will recognized as the valid will and appointing the executor and giving them legal authority. Most estates have to go through probate. If you own property, you have to. The only way to avoid it is typically by transferring everything to a spouse. And or having a small estate that's valued at, I believe it's less than $50,000 to $75,000. Other than that, I would assume that you're going to go through probate, although you can talk to a tax specialist about how you can do things to avoid it, like create trusts, gifts while you're alive, etc. I'm not going to speak to that today. So I have a question about, can I gift money in a will to avoid probate? The answer is no, but there are things you can do to reduce your probate fees, and that would be speaking to a tax specialist. So hopefully that helps. And no, you don't have to update your will if you move in with your boyfriend, but I'll talk about that a little bit later. So who can this be? I had a question in advance about, no one comes to mind to be my executor. So most people would choose, a spouse, family member, or close friend. For example, I've appointed my husband, Kevin, as the executor in my will. But this can be, anyone from, an uncle or a parent or a sibling to a close friend. The thing to remember is it's a lot of work. It can take 12 to 18 months. So if you are asking someone to do this, know that it is a burden on them. And it might be an honor, but it's definitely a lot of work. If no one comes to mind in your life, you can also appoint a professional. So there's a firm called ETP Canada Estate Transition Planners, and they are professional executors. Debbie and the team over there are great. And so you can appoint someone like Debbie and her team, or a lawyer or a trust company to act as a professional executor. It's not something we support on Willful at this time, but it can be a great option if you can't think of someone to act in that role. So what do you think about when appointing your executor? Well, it's important to consider the 3 T's: time, trust, and territory. Time is simple. Will this person have time? If I appoint Oprah as my executor, probably not going to have time. What about trust? Well, I need to trust the person that they're going to do the right thing. There was just a story in the UK about an elderly woman who left her estate to her child, half to her child, half to her 2 grandchildren, her son's niece and nephew. To the person who asked about how to account for grandchildren in a will, it's very common to leave a cash gift to a grandchild, but some people choose to leave a percent of the estate like this woman did. But unfortunately, her son was not trustworthy. He was the executor, and even though he was only supposed to keep half of the estate, he kept 100% for himself, and the grandchildren are now suing him for their share. So you want to make sure that you trust this person to do the right thing. They have a legal liability to do that, but not everyone does. Finally, you want to consider territory. Where does this person live? Do they live close to you? If they don't, are they going to have to be on site to deal with your physical property and funeral and burial wishes? And is that tenable for them? If they live outside Canada, you should also note that there can be major tax implications because it changes the location of your estate. So if you are going to appoint an executor outside Canada, for example, your sister in California, you may want to speak to a tax specialist. Yes, your executor can be the child who will also be your beneficiary. That's very common. I'm the executor of my mom's will, and I would likely be one of her main beneficiaries, although she doesn't have to tell me that because you don't have to share the contents of your will with anyone. But my second bullet point here illustrates that perfectly, which is you should discuss it first with your executor. They can turn it down. If someone names me as their executor, if I name Oprah here, Oprah can say, no, sorry, I've never heard of Erin. I don't have time to be her executor. I decline that role. That's why on Willful, we guide you through adding secondary executors. So if the primary person can't do it, it moves on to the secondary. In my case, I've added my husband as my primary executor, my sister as my backup, and my mom as my second backup. So in case my husband and I were traveling with my sister and we all passed away at the same time, there would still be someone who would be able to act in that role. And we guide you through that. I'm just reviewing the questions here. What do you do if you know an executor has not followed a will and kept more than their share? That's when you contact an estate litigation firm who can pursue that with them. It's not something that I'm an expert on or that we deal with at Willful. Can executor also be a beneficiary? Absolutely, they can be a beneficiary. It's very common. As I mentioned, my husband is my executor. He's also the main beneficiary of my will. There's some questions about executing wills here. I'm going to be answering that a little bit later. And can executors be witnesses? Great question. Executors should not be witnesses because they are entitled to compensation. So anyone who benefits from your will should not be a witness as a best practice. There's a formula in each province that outlines how much executors should get paid. So you don't need to specifically outline it in your will because the courts will appoint them the appropriate compensation based on that provincial formula. But that's why they shouldn't be a witness to the will because they actually are benefiting from the will. So I'll move on, but I will keep an eye on the questions. And if I haven't got to yours, it's just because I'm going to answer it later. So the second step when you are creating your will is to choose your beneficiaries. So this is answering the question, who do you want to get your assets? Now, if any of you have seen this movie, Knives Out, you know that it can be contentious in families when someone passes away. Everyone's arguing over who gets what. But I wanted to make the point that you only have a legal obligation to support a legal spouse and any financially dependent children. So that's not just minor children, that's financially dependent children. So if you have a 25-year-old that lives with you and doesn't pay rent, that would be considered financially dependent. So I have to account for my husband and my 1-year-old daughter in my will. Other than that, I can leave things to whomever I would like. And if you don't have a spouse or a minor child, then it's really up to you. You can leave things to charity. You can leave things to friends, to siblings, whomever you would like. As I mentioned, if you pass away without a will, then the government formula is going to distribute that to a list of your relatives, starting with your spouse, then children, then parents, then siblings. So having a will that appoints beneficiaries is the best way to make sure the people you want are on the receiving end of your assets. I also wanted to highlight what's not covered by your will. So you don't have to update your will every time you get a new bank account or buy a new car. You don't include a detailed list of your assets in your will because you wouldn't want to update it that frequently, and because your will becomes a public document when it goes through probate. And you don't necessarily want your neighbors and your So at the time you pass away, your will covers everything that you own outside of these things. So for example, If you have a joint bank account, it's just going to transfer to the other owner. So if I pass away tomorrow and my husband and I have a joint bank account, then that account just becomes his. It doesn't flow through my will. Same with any joint investments or jointly owned property. So for example, we own this house, what's called jointly with rights of survivorship. That means that if I pass away, the house just transfers into my husband's name automatically because he's the joint owner, and it's not going to have to go through probate. So when someone asked about how do you avoid probate earlier, these are examples of how you can avoid probate. You can have joint bank accounts with a spouse. You can have joint investments. You can have jointly owned property that automatically transfers to the other owner. You can have registered savings accounts like RRSPs or TFSAs. Typically, those have beneficiaries named directly on them. For example, I have an RRSP. The beneficiary of that RRSP is my husband. I pass away, it gets paid directly to him. It does not flow through my estate. It is not part of what's covered by my will. Same with any pensions that have named successors on them, or importantly, life insurance policies. If you have benefits through your workplace, if you have your own life insurance, typically you appoint an individual on that policy. And that's a good thing because it gets paid out way faster in 2 or 3 weeks versus 18 months. And it avoids those pesky probate fees, which are equal to about 1.5% of your estate when you pass away. So I think that answers the question here. What happens to joint liabilities? So when you pass away, if it's a joint debt, let's say, for example, I have a line of credit and it's a joint line of credit between my husband and I, that debt just transfers to him. It doesn't disappear when you pass away. It just transfers to the joint holder of the debt. Mortgages stay with the home. So let's say, for example, I pass away and I leave my house to my sister. If the house has a $200,000 mortgage on it, my sister can either decide to assume the mortgage and pay it off, or she can sell the house and pay off the mortgage and keep the difference. So mortgages typically stay with properties. Hope that helps answer that question. And I'm actually not sure about alimony and whether that's considered a debt that's transferable. That would be beyond the scope of my knowledge and a question for a family lawyer likely, but thank you for that question. So other than everything I've highlighted on this slide, everything you own at the time of your passing flows through your will. So that can be bank accounts, it can be investments, it can be homes that you own on your own, cars, boats, jet skis, your wardrobe. You name it, it comprises your estate when you pass away. Your estate is everything you own. So who can you leave those assets to? Well, you can leave assets to individuals. They can live anywhere in Canada or around the world. Note that in Canada, we don't have inheritance taxes. So if your grandmother leaves you $50,000 in her will, you get that money free and clear. The taxes have been paid by the estate. Whereas if you live in the UK, for example, there's a 40% inheritance tax. So that $50,000 would come to you and then you'd have to pay $40,000. So if you're leaving something to someone in the UK, just be aware they're going to get taxed on it. Your beneficiary can be the same person that you've appointed as your executor or the same person that you've appointed as the guardian for any children or pets. And I've had a bunch of questions about minor beneficiaries and children. How do I leave them assets? How are those assets held if they're young? Great question. So my daughter's a year old. If my husband and I passed away tomorrow, all of the assets that we've left her would be held in a trust. Willful wills automatically trigger what's called a testamentary trust, which just means a trust that's created upon your passing. Those assets would be held in that trust until the age that I specify in my will. On Willful, you can specify one age or multiple ages. So for example, for me, I've left half of the inheritance to Amelia at age 21 and the other half at 25. I don't trust her at 18 to be responsible with it because I would not have been. So you can choose the age of majority, which is 18 in Ontario, or you can choose to stagger that over time. Those assets will be held in trust and managed by the trustee, who is also the executor that you appoint in your willful will. And the executor can release some of those funds to the guardian for ongoing reasonable care. So things like tuition, school, food, lodging, family vacations, etc. So hopefully those answer the questions about minor beneficiaries, but let me know if it doesn't. Yes, there is an inheritance tax in the US. I'm not 100% sure what it is. I do know if you go on Wheel of Fortune and win $20,000, you pay 50% tax on any winnings, whereas in Canada, any lottery or game show winnings are tax-free. So I assume it's similar with inheritance taxes. And no, I have not been on Wheel of Fortune, but it's a life goal. So we talked about individuals that you might want to leave things to. But you can also leave things to charity in your will. And this wasn't something I was aware was a possibility, but it's such an easy way to have a positive legacy, to leave a positive legacy, to have a positive impact that doesn't cost you any money right now. When you leave a gift to charity in your will, it reduces your final tax bill. So when you pass away, your executor, unfortunately, still has to file your taxes with the CRA, still has to be responsible for that final tax bill. And if you have left a gift to charity in your will, it can reduce that final tax bill. We've had so many gifts left to charities like McMaster, charities and organizations. So school and alumni associations are a great example. And here's an example of a headline I love. This Peterborough woman left almost $1 million in her will to the Humane Society. There's also some great examples of McMaster grads who have left legacy gifts that have helped to really make a difference at the school. So when we partner with organizations like McMaster, we always try to highlight that, it's such a great option. If you loved McMaster, if you love being part of the community, maybe you don't have the capacity to donate now, but on Willful, we make it really easy to leave a gift to charity. McMaster is one of our selected charities, so you can just select them from a drop-down menu, and you can choose to leave a % of your estate or a cash gift, and I'll talk about that in a moment. This is also a great option if you don't have anyone in your life that naturally comes to mind as a beneficiary. You're not married, you don't have any kids, you love your friends, but you don't really want to give them all of your money. Charity can be a really great place to direct those funds. So how do you actually distribute your assets in your will? Well, there's a few ways. We'll walk through each of them in detail now. So the first way is called a specific gift or a bequest. You might have heard those terms before, but what it is it's a specific item that you leave to a specific person. So for example, I have left my wardrobe to my sister because we're the same clothing size. This might be leaving a special painting to someone, a musical instrument, a baseball card collection, shares in a company could be considered a specific gift. For example, the doctor who was asking questions earlier, this is where you might want to leave shares in your company to someone else. This is optional too. So you might have nothing that fits into this section, or you might have 100 things. You can get as detailed as you want. And, as you get new items that you want to leave as a specific gift, or you get rid of things that you've left in the will, this might be an example of when you might want to update the will. You can also, as I mentioned, leave a cash gift. So this can go to charity or an individual. Someone asked earlier about grandchildren. It's very common for grandparents to leave a cash gift to their grandchildren in their will, $5,000 or $10,000, something like that. This is where you would do that. You could also leave a cash gift to a charity. So for example, you can see here that I've left $25,000 to McMaster University. And that's a great option to leave a set amount of money in your will. Lindsay has just put some great information in the chat about how to contact McMaster if you want to talk to them more about legacy planning. So you can contact Eli in their estate giving and legacy planning division, and they can give you more information. And we also make it easy to just go through the process and leave money to causes that you care about on Willful. So everything that's left after, so your executor is going to pay all of your debts and your taxes and pay for any funeral, burial expenses. They can also hire accountants and lawyers to help them, and that would be considered an expense of the estate. So all of those expenses are going to be paid for. And then they're going to pay off any of your debts or liabilities, like a credit card debt, for example. They're going to file your tax return and pay any taxes owing. They're going to give out those specific gifts like the baseball card collection and the piece of art. And then they're going to distribute those cash gifts like the $25,000 to McMaster. And everything that's left is called your residual estate, which is just a fancy word for the pot of assets that are left. I hope this is a lot of money. I hope it's $500,000. And what you're going to do is divide it up by percentage. So it's really simple. Think of it like a pie, and you're breaking up that pie chart. This can be 100% to one person. For example, I've left everything to my spouse, Kevin, if I pass away first. And if both of us pass away at the same time, I've left everything to my daughter, Amelia. On Willful, we guide you through not only appointing the primary beneficiaries, but also appointing backup or secondary beneficiaries in case you and the primary beneficiaries pass away at the same time. So it's a pretty easy way to divide up your estate. The hardest part is just figuring out who you want to leave things to. And I can tell you that it's a very personal decision, but it's very common to leave things to a spouse, siblings, parents, children, charities, and or friends. Great question here. What if your debts outweigh your assets? Well, then you have what's called an insolvent estate, which means that you are essentially bankrupt like you would be in life. And then your executor has to go through a process whereby all of the beneficiaries have an order of being paid out. So creditors have an order, like the mortgage is typically first, followed by credit cards, etc. And then hopefully there's something left to pay out to beneficiaries. If there's not, then unfortunately, the beneficiaries aren't going to get anything, and the estate money is going to be used to pay off debts. So it does happen, but hopefully it doesn't happen to you. I highlighted earlier that you typically don't include a detailed list of assets in your will, but I did want to highlight with a platform like Willful, we're trying to help you create a really comprehensive estate plan. So in addition to being able to make your will and power of attorney documents, you can also notify key people that you've named in the will by sending them an email about their role. And you can create an asset list, which, as you see on the screen here, helps you to list out the assets that you own and the liabilities that you own. This is not a legally binding document. It's just something to store with your will that's really helpful to your executor. The third and final step in your will is naming guardians. Obviously, this is one that is very close to my heart, having a 1-year-old, and it's answering the question, who would look after your children if something happened to you? So this is our daughter. This was her at about 6 months. She's just over a year now. And yes, we use her as our unofficial Willful spokesperson, even though the only word she says is dada, much to my chagrin. And, after she was born, as I mentioned, we had to decide who we wanted to appoint as guardian. This is a really emotional decision because it's asking you to contemplate who will take care of your child if you and the other parent are not around. If I passed away tomorrow, Kevin would just continue to parent our daughter. This is only in the event that both of us pass away together. But it's a super important decision. So a few things to note on guardianship, again, only comes into effect if there's no surviving parent. It's typically a family member or a close friend, but it can be, anyone in your life. The guardian can live outside Canada, so it's very common to have guardians that are in another country, but they're the closest family members. And there, as I mentioned earlier, if you have a minor child, then your assets are going to be held in trust for that child. And on Willful, we help you appoint an age at which they would receive that inheritance, or you can stagger it over multiple ages. And the guardian would have access to those funds. The executor would release them to the guardian. And the executor and guardian could also be the same person. For example, my executor might be my sister and the guardian's my sister. And so then she would just be able to access those funds herself. As I mentioned, we don't account for creating Henson Trust for children with disabilities, so you will need to visit a professional if that's something you want to add to your will. But we can't forget about pets. Often pets end up in shelters because their owner has passed away and hasn't made a plan for who would take care of them after they passed. And so it's really nice to appoint a pet guardian in your will, have the conversation with them, also have the conversation with the human guardians. It's a big decision to become an instant parent, so you don't want to spring it on anyone. And like the executor, they can turn down that role and say, no, I'm not interested in it. So definitely something you want to discuss with them. And you can also leave not just a pet guardian, but you can leave funds for your pet's care. So, in the willful will, the clause says, if so-and-so takes on the responsibility of caring for my pet, give them X amount of money to pay for vet bills and pay for their care. You don't have to leave money for their care, but, my mom has 2 horses and they're expensive animals. So it's a nice thing to do. Thanks, Nikki, so much. And I am going to keep going. I'll come back to some of the questions. I just want to make sure we get through the main points and talk about the important part, which is executing your will. So you've made the 3 key decisions in your will. You've named an executor, you've named beneficiaries, you've named guardians for minor children or pets, but you're not quite at the finish line yet, because as I mentioned, for a will to be legally valid, it has to be signed and witnessed according to provincial law. So on Willful, what we do is we provide you PDF documents that have a detailed instructions page on how to execute the documents and who can be a witness and who can't be a witness. Once you've actually gone through, I think I answered most of the questions about witnesses, but let me know if you have any more. But once you've gone through that signing and witnessing process, you're going to store a paper copy safely. So again, you have to have a physical copy of your will unless you live in British Columbia. Then you can actually have a digital copy of the will. And then you're going to tell your executor where it is and how to access it. So the key thing is so many people pass away and their family has no clue if they have a will or where it is. So it's useless to your family if they don't know it exists and don't know where to find it. And if you're concerned about them, peeking at it or seeing the contents of it, you can keep it in a safe or, keep it somewhere where they can't see it. But the executor does need to know how to access it. And hopefully you are choosing, someone as your executor who you trust with that information. We also on Willful give you a free registration on the Canada Will Registry. You are not registering the physical document because it's not legal to store it online. What you're registering is details about the will itself, when you executed it, who your executor is, where it's stored. So if you did pass away and your family didn't know where it was located, they can pay to get those details from the registry and hopefully locate the physical copy. That is an optional step and you do not have to do that, but we give you free registry with every Willful plan. So I had a few questions earlier about updating a will. And I do have a question here about, do you need the original paper copy? What if you've been left with a duplicate? If there is a question about that, that might be something that the courts have to weigh in on. So when you're applying for probate, for example, they might have to assess the duplicate copy. A duplicate copy is better than nothing, but the original is always preferable. And so, if you do have a duplicate, the courts might have to assess it and jump through some hoops in order to allow that copy to be used. Can you do joint guardians for children? Typically, you could do a couple or an individual, but you couldn't do, for example, your aunt that lives in Kansas and your uncle that lives in Florida because they are in completely different states. Typically, the family court will allow you to do an individual or a couple, not 2 random people that don't live together. And again, it's only if there's no surviving parent. So if you're divorced, for example, the other parent would typically just take on guardianship unless there was an issue. And then really the family courts are the ones who step in around guardianship. So I'm not a family lawyer. I don't have a ton of detail on that process of appointing the guardians after you pass, but the family courts do handle all of that. So updating a will. First, I wanted to talk about who needs to make a will. I had a question about couples, and I often hear people say, well, I'm making a will for my parents, or I'm making a will for my spouse. I want to highlight, you cannot make a will for someone else. You have to make a will yourself. You can help someone. For example, I sat with my dad, helped him through the Willful platform. He told me the decisions that he wanted to make, but you have to make the will yourself and be making the decisions yourself. That being said, wills are like tax returns. You each need to have one. So you're not going to make one joint will for you and your spouse. And that's simply because you each have your own estate when you pass away. Chances are you are going to pass away at different times. And so even if you have a ton of joint assets, you are going to have some things that fall under your estate, and your will governs that. There is a very niche product called a joint will, used by typically people in blended families or second marriages. It is not used commonly because it means legally you can't change your will after your spouse passes away, which is, not practical if, let's say, you remarry in future or have another child. If you want more information on that, you can speak with a lawyer, but it is not commonly used. So, when should you update a will? Well, first, you can use Willful to update an older will. You're not going to update that specific copy of the will. You're going to execute a new version of the will. The only person that will update that will that you had drafted 20 years ago with a lawyer is that specific lawyer. No other lawyer will update another lawyer's will. And with Willful, we're not going to update an older copy because we have our own lawyers that draft all of our legal content. So what you're going to do is you're going to execute a new will on Willful. Automatically by law, it revokes any older version and you just destroy it. It's that simple. You should update your will when you have a child, when you get divorced, to remove the person from your will, if you move to a new province. Although I do want to highlight that your will is not invalid if you move to another province. A will created in one province will work in another province. Your executor will just have to go through some hoops with the courts in that province. And it's best practice to update it when you do move provinces. You may want to update your will, as I highlighted earlier, if you get rid of or acquire a new item that you want to leave as a specific gift, or if any of the roles in your will change. You appointed your best friend as executor and you two had a falling out, get her out of the will. You got divorced, get him out of the will as executor. Your mom passed away, unfortunately, and you named her as executor, remove her from the will and add someone who can actually perform in that role. The goal with updating a will is that you die with a will that reflects your current life situation and current wishes. So if that means you never have to update your will, great. If it means that you're updating it once every 5 years, great. But I know a lot of people out there created a will 30 years ago. It's sitting in a filing cabinet, gathering dust. They haven't updated it to reflect their children and all of their current wishes. And so this is your call to action to get that will updated. The good thing about Willful is that we offer free changes at any time. So you pay a one-time fee, and I'll go over pricing momentarily, and you can come back and make changes. You do have to go through that signing and witnessing process. Essentially, you're executing a new will every time you make a change, and you're just revoking the previous version, destroying that older version. And so that is free on Willful. If you're getting your will updated with a professional, you're usually paying their hourly rate, which can be, $200-$300, depending on the professional that you work with. Now, today's session focused on the will, but I want to highlight that a will is just the tip of the iceberg when it comes to a comprehensive end-of-life plan, which is not meant to sound overwhelming. Create your will this year, check it off in 2022, and then in 2023, let's add power of attorney documents to the list. And that's really answering the question, who would make decisions for you if you couldn't? This is asking, okay, if I was incapacitated due to illness or injury, who would actually pay my bills, make medical decisions for me, and manage my life? That's the person that you're naming in your power of attorney documents. There's 2 documents, one for healthcare, one for finances. And this is often the same person as your executor. For example, I've appointed my husband as my attorney, my sister and my mom as my backups, just like I did for my executor. You've probably heard the term living will. We don't use that a lot in Canada, but it's essentially the same thing. So I wanted to, before I get back to the questions, just take a couple moments to talk about Willful. Again, we're so thrilled to be a partner of McMaster, and really the ethos behind Willful is to make estate planning, to destigmatize it, to make conversations about end of life more common, and to make it really super simple to get your estate plans in order. We've tried to make making a will as easy as filing your taxes on TurboTax or investing your money on Wealthsimple. So you can forget appointments in person. It's a streamlined online process, and most people complete it in under an hour. Now that you have the decisions that you need to put in your will, it's about 15-20 minutes. So how does it work? As I mentioned, we partner with estate lawyers in each province. They write all of our legal content from the ground up, and they're on contract with us to keep it up to date as legislation changes. We guide you through, learning a bit about your life situation and tailoring the questions in your will based on that, helping you appoint your executor, beneficiaries, and guardians. And we also help you outline funeral and burial wishes as well. We give you this customized set of PDF documents with an instructions page that outlines how to sign and witness them to make them legal. And as I mentioned, you get free updates to those documents anytime in future for free. We launched about 5 years ago, and since then we've created over 100,000 documents for Canadians. We have great reviews on Trustpilot that I encourage you to check out. We have other great partners like Allstate Insurance and CIBC Bank, and we even scored a deal on TV's Dragon's Den in 2021. So I encourage you to check out our segment if you're a fan of the show. So someone asked earlier the difference between Willful's 3 pricing plans. So first I wanted to flag that as a McMaster grad, you get 10% off any Willful plan. You can click the link that Lindsay will add into the chat right now, or you can watch for that post-event email and it will include the link and the recording in there. So our plans, our Legal Essentials plan is $99. That comes with just a will and no power of attorney documents. So 1 document, the will, and free updates in future. The middle plan, the premium coverage plan, comes with a will and both power of attorney documents for healthcare and finance. And that also includes free updates. That's $189. And the premium coverage for families plan on the right is everything in the middle plan times 2. So if you're creating a will alongside your spouse or a family member, it's $329 for both of you. It comes with a will and power of attorney documents for you and your spouse or family member. And realistically, I mean, especially in a city like Toronto, 1 hour in a lawyer's office is about $300 minimum. And so for the cost of many hours in a lawyer's office, you're getting some great documents that have been created by estate lawyers in Ontario, based in Ottawa and Guelph. We also have some plans in Quebec, which I'm not going to go into in detail, but if you do live in Quebec, we have a fully bilingual site and a unique product called the Notarial Will, which is only valid in Quebec because they have a different legal system. So that was my estate planning power hour. I want to say thank you so much to McMaster for having me and remind you to get your will done, whichever way you choose by the end of 2022. Don't go into the next year with this on your New Year's resolutions list. And, as I mentioned earlier, so many folks pass away without a will. Aaron Carter, the singer, passed away without a will, left a fiance and a young child and no wishes for how he wanted his estate to be distributed. So please don't be the person who says, I'm too young or I don't have enough assets to need a will. And if you have questions about wills, estate planning, anything related to what I've talked about, you can reach out to our support team, support@willful.co or willful.co/support, and we'll point you in the right direction. I know we have a couple minutes, so I'll get to a couple final questions. I did answer a question earlier about corporate. If you don't have a separate will for your corporation, your will covers your corporate assets. And so we have a clause that adheres to that. And do you update on marriage? In Ontario, your will used to be invalidated when you got married. They've changed that law since then. So you do not need to update your will when you get married, although you may want to add your spouse into key roles if they weren't already reflected there. How would you fairly divide a cottage between 4 adult siblings? That is a question that is, one thing I want to highlight on Willful is that we help you outline what you do want to happen. If you want to disinherit or leave someone out of a will, or you think there's going to be contention, you may want to work with a lawyer because they can write in a lot of that language. And I did have a question about what happens if a will is contested. Anyone can bring a claim against a will regardless of who created it, but that person has to show support. So to our knowledge, no willful will has been contested in court, but it will be because every will gets contested. Not every will, but every type of will be contested in the future. But the best example of your intentions are recording them in a will. That is the best evidence of your wishes. Without a will, anyone can come out of the woodwork and try to claim an asset. And that government formula, again, is going to divide things up. So I will leave you with that. I know there's quite a few questions I didn't have a chance to answer. Please reach out to support. We'll point you in the right direction, even if we're not the right people to answer it. And I want to say thanks again for coming tonight, and hope everyone has a great rest of your evening. Back to the McMaster team.
Thank you so much, Erin, for joining us tonight. You gave us a lot of great information to work with. And like Erin said, make sure you check out the try.willful.co/McMaster and any of their support or websites. And thank you so much for joining us. Have a good night, everyone.